Welcome everyone to the IAPP web conference, Ready for CPRA, Pragmatic Steps to Take Now, sponsored today by Securiti. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the name registrants with 1 CPE credit. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, My Recordings portal. So if you just log into your account at the top of our website and then you go to My Purchases and My Recordings, you'll see the video and the PDF of the slides within 48 hours there. Please feel free to post any questions you have for the panelists in the Q&A area at the bottom of the screen. Throughout the presentation, we do have a designated time period at the end for Q&A, but we might take some throughout the program as well. So now onto our program. I'd like to introduce today's panelists. Firstly, I'd like to introduce Michael Morgan and Saba Bajwa. Mike and Saba are joining us from McDermott, Will & Emery in Los Angeles. Mike is a partner and the US leader of the firm's global privacy and cybersecurity practice, and Saba is an associate. Welcome both of you. Next on our panel, we have Nigel Hawthorne. Nigel has been talking about data protection and privacy for around 8 years. He wrote a book on GDPR called GDPR, an Action Guide for IT, and helps write privacy materials for security and speaks at conferences. Welcome, Nigel, as well. And to round out our panel, we have Vivek Kokangada. Vivek is VP of Products at Securiti and handles all aspects related to data privacy tech within the product. We're really looking forward to this conversation. And with that, I will hand it over to our panelists.
Great, thanks, Jordan. So here's the agenda, but just to point out, there's always lots more material than we can cover. So we will be going through this relatively rapidly, but there's always space for you to ask Q&A either during the event or of course afterwards contacting any of us. And also at the end, you'll see that the last bullet there is further information. I'll be sharing places you can go to read more information, and actually a previous webinar that Mike and Vivek were on that goes into a little more detail on some of the aspects of CPRA. So Jordan, do you want to pick up the survey question now? Would that work for you?
Yep, it's
Here
launched.
we go. Yeah. So, which term would best describe your company's level of readiness for the effective date, of course, of January the 1st? And I can see lots of answers coming in. Wow. 37, 48, 55. Great that so many of you are answering and letting us know where you feel you are. So, okay, still coming in. So you can see that there were 5 different options here. My company's ready. My company is probably on track, probably not on track, definitely not on track. And honestly, I have no idea whether we're on track or not. And with a bit of luck, this webinar can help you work out the answer to that question. Well, the most popular answer was the second one, which is that my company is probably on track, with 43% of you saying that, and 16 to 18% choosing the other 3 main options there. My company is ready or firmly on track, it's probably not on track, and I don't know. So the good news is only 4% of people said that you're sure your company is definitely not on track. So let's see, after this hour, maybe we'll all be able to get more on track and make sure that we can put in the things that we need to conform to CPRA in January. So, okay. Let's just remind ourselves that, of course, CPRA is, just one of the things that we have to conform to, and that across the US at the moment, 35 states have either got drafted or passed bills, and that it covers about 85% of the population of the US. Of course, we've got bills in places like the EU with GDPR, and lots of other countries are introducing very similar laws, though they all have their own nuances about how long you have to inform them of issues, or nuances upon how they define what is sensitive data, and we'll dig into some of that. And the important thing, I think, to remember about all of these is that state that is defining the policy is the state that is the residency of the data subject, not of you as a company. So even though you may be based in one state, you need to be able to look at and be able to conform to all of these different bills as they come forward. So I'm going to pass over to Mike now, and he's going to take a couple of slides to talk about what is new in the CPRA, especially compared to the CCPA. So over to you, Mike.
Yeah, thank you, Nigel, and good morning, everyone. Just want to spend a couple minutes talking about some of the key highlights from CPRA. And starting with the expiration of the exemption for employee and B2B data. So as of January next year, those exemptions are going to be going away. And in the meantime, California employers and B2B companies need to be focused on their compliance efforts with respect to that no longer exempt data. Also, another highlight is that there's a new category of sensitive personal information. This aligns with more aligns with GDPR, and it includes some stringent requirements, including requirements for disclosure and purpose limitation with respect to sensitive personal information. Another key development is the addition of some new consumer privacy rights, including the right to limit the use of sensitive personal information. We're going to talk more about that later. The right to correct personal information, the right to access information about automated decision-making, and the right to opt out of automated decision-making, including profiling. There are additional requirements with respect to data for minors, including an obligation to obtain consent, opt-in consent, before selling, sharing for behavioral advertising purposes, data of individuals younger than 16. And there are additional rules requiring parental consent with respect to individuals under the age of 13. There are new contracting requirements with service providers and third parties, and a new category of contractors. That's going to require us to revisit contracts that have already been revised for CCPA. It's going to require sort of another round of changes for some, but not all of those agreements. Next slide, please, Nigel. There also are expanded notification requirements under CPRA. At point of collection now include data retention information. You have an additional notification obligation with respect to sensitive personal information, the collection and use of that, and notification to minors for the sale sharing of their PI, disclosure of categories of PI shared and with whom in privacy notices, and then an important one, disclosure of data retention periods in privacy notices. There is a additional cybersecurity requirements, including a clear requirement to maintain reasonable security with respect to personal information, and specific requirements, a requirement to perform an annual, thorough, and independent cybersecurity audit and periodic risk assessments that need to be submitted to the California Privacy Protection Agency in situations where personal information presents significant risk to consumers. One of the more important sort of practical provisions is that CPRA creates the new California Privacy Protection Agency for enforcement and interpretation of the CPRA. This is a huge issue with enforcement being transferred from the AG to this new agency. And I think all just at a high level, there are a lot of provisions here, a lot of provisions that require interpretation. My colleague Saba has been tracking the developments in rulemaking, and Saba, do you want to talk a little bit about that?
Yeah, for sure. Thanks, Mike. So like Mike said, the CPRA established the California Privacy Protection Agency, which we call the CPPA, just to add another very similar sounding acronym to the mix and make things even more confusing. So on May 27th of this year, the CPRA released draft regulations, and those regulations add some detail and some color on how to actually comply with a few of the new CPRA obligations. So throughout the presentation, Mike and I will kind of touch upon the regulations that are relevant and where we think that there might need to be additional guidance to actually comply with those requirements in practice. And on June 8th, the CPPA had a meeting to discuss these regulations, during which they started the rulemaking process. And they noted that they expect the regulations to be finalized in late Q3 or Q4 of this year. And absent any substantial changes or substantial comments from the public or stakeholders introducing any major amendments to the regulations, they said that they do anticipate the regulations to be finalized largely as they stand right now.
Yeah, thank you, Saba. Let's go to the next slide, Nigel. Just want to take a couple minutes and talk about one of the new rights, the opt-out right with respect to the sharing of information. The world of it's not an overstatement to say the world of digital advertising has been in considerable flux over the last few years. This development is going to sort of continue that trend. The CPRA expands the do not sell opt-out requirements and extends them from the sale of information to the sharing of information. Sharing is defined as a business that is communicating a consumer's personal information to a third party for cross-context or third-party behavioral advertising, and it does not matter if it's not for monetary or other valuable consideration. So what is considered cross-context behavioral advertising? That's the targeting of advertising to consumers based on their personal information obtained from activity across businesses, distinctly branded websites, even if they're owned by the same owner, applications or services with which the consumer intentionally interacted. The effect of this is that it expands opt-out rights to buy-side advertising activities that previously were at least arguably exempt from the sale and opt-out obligations under CCPA. Saba?
Thanks, Mike. Yeah, on this last point, under the CCPA, it was kind of a question as to whether processing the global opt-out signal was optional or required. And the CPRA kind of clarifies that yes, processing these types of global opt-out signals is required and they must be treated as valid opt-out requests. So this means a few things if you sell or share data and if you have a website. One is obviously that you should be thinking about technical changes that need to be made to your website as the end of the year approaches. But also two, the CPRA requires that if a consumer had an opt-out signal in the past, but then later revisits your website and no longer has the signal, you still need to treat that consumer as having opted out. So it would also be wise in the absence of additional guidance on how to operationalize that specific requirement to start to think about keeping a record of the consumers that have visited and implemented this global opt-out signal, or maybe a record of IP addresses to kind of help you implement this change and comply with that requirement as we wait for more details on what that should actually look like in practice.
Great, thanks, Saba. Well, that I think brings us to Vivek to be able to talk about how we can operationalize some of that. So Vivek.
Sure, Nigel. I think we're looking at a couple of ways, at least from experience and working with a couple of customers. The way to front end and track some of the behavioral signals and enable a platform to be able to honor such things could simply start by ways in which any solution that is implemented can honor signals that are coming from whatever interface the customer is using. And for example, the global privacy control or the browser signal that the customer may have predefined can be automatically used or honored to implement some kind of an opt-out signal within the banners itself, whether it is presented within the browser. And that can be used as a signal to prevent the tags or cookies from being dropped, which will then propagate and could be used as a way to prevent the use of behavioral advertising and other signals that can be shared with other websites and vendors, and therefore you can enable some of that out of the box itself. So these are some ways in which you can honor some of the signals that are being sent out by the customers themselves. Let's go to the next slide, please. There are also instances where obviously through the CCPA timeframe, the need to put out do not sell links or buttons themselves and use that to provide some of these signals, that still applies, that's still being used by several customers. And of course, that text is now being adapted to say sell or share. Of course, this can also send out signals up front to whether it's to Google advertising through API calls or dropping IAB cookies and making sure that this propagates as the user goes to other sites and you're not sharing information from that perspective. But we also see a lot more what I call as interactive workflow-driven approaches, where whether through the privacy notice or through the banner itself, there are do not sell or share buttons and links that will then essentially initiate workflows in the backend that can be utilized to propagate this do not share information through particular activities. So you can signal processing activities that are happening within the environment itself, whether it is putting the customer in a golden list that says this information shouldn't be shared, or taking them out of a list or taking out their information, and making sure that you're honoring some of these opt-out signals that are coming and enabling that to flow through. It can be any type of environment, whether it is your own processing environments, whether you're using the data for your own data processing activities, whether you use sensitive personal information for processing activities that are considered highly risky. You can propagate these signals, or you could be propagating it to external environments, partners, or your own marketing tools, so that you don't end up doing additional processing activities once the customer opts out or sends these signals, whether it is through the automated signaling capability or by actively activating some of this through your privacy notice links or through your do not sell links themselves.
Great, thanks. Let's go back to Mike and Saba now and dig a bit more deeply into what is sensitive personal information and what we need to do about it.
Yeah, thanks, Nigel and Vivek. So as I noted before, the CPRA creates a broad new category of personal information, sensitive personal information. And it gives consumers new rights to limit the use and disclosure of sensitive personal information. Separately, businesses are going to be required to include distinct disclosures of their collection and use practices with respect to sensitive personal information in their privacy notices. So this is going to require updates to data maps and consumer privacy notices. The definition of sensitive information includes all the categories that are listed on the slide. So it's a fairly broad definition of sensitive personal information, and in line with the broader definitions that are found in other progressive privacy laws. And then next, businesses that process sensitive personal information must allow consumers the right to limit the processing of that sensitive personal information to certain purposes that are generally necessary to perform the services or provide the goods. And that would include processing for the purposes where it's necessary to perform or provide the requested goods or services that would be in line with the reasonable expectations of an average consumer. It can be used for security and integrity purposes. Short-term transient uses are okay, as are storage and account service uses, and to verify, maintain the quality and security of devices or services.